having been sentenced, once the child is released, the state is going to take it upon itself to assist the child after sentence to really try to go straight. Because, Mr. Speaker, members of Parliament, my colleagues, we will be doing everything to assist the young wrongdoers in our society to go straight. It is not our intention that these wrongdoers should just be charged, prosecuted, and incarcerated. We want to do everything within our powers to ensure that at every stage we give the child as much assistance to really lead on a straight and narrow path. So, having made those comments, Mr. Speaker, we will go to committee, but I'd like to emphasize, colleagues, that this bill could be a game changer in the court system. In many countries, Canada in particular, because of child diversion, many of the young offenders' institutions have closed down. And I would like to see if this can be implemented, that we can avoid many of these child and approved schools and other institutions that we send our young people to, that they are deprived of offenders, and therefore we can close them down. So, Mr. Speaker, this bill could be a game changer for us to save our children, diverting them away from deviant and delinquent behavior. And so, Mr. Speaker, this Parliament, in passing this bill this evening, will be sending a clear message to all Jamaicans that we will be doing everything to allow our children to lead a straight and decent life, without, Mr. Speaker, condemning them to a life of criminality, which is the usual consequence when we charge and institutionalize them in these various young offenders' institutions. Mr. Speaker, in closing, I want to remind my colleagues that our children are our future, and every single one must be assisted. Our families, neighborhoods, and communities, the village, must help in raising the children. And therefore, when they go wrong, we all have to participate. And the Ministry of Justice, Mr. Speaker, will be undertaking several training programs, several sensitization across the country to ensure that this bill is implemented and as many of our youngsters can in fact be saved from themselves, from their families, from the gangs, and hopefully be able to contribute to a better Jamaica. So, Mr. Speaker, I now ask Mr. Speaker, that the bill be read a second time.
The question is that the bill be read a second time. Those in favor? Aye. Those against? The ayes have it.
A bill entitled An Act to Facilitate the Implementation of Child Diversion in the Criminal Justice System and for Connected Matters read a second time.
The House will now resolve itself into a committee of the whole House to consider the bill clause by clause.
Mr. Speaker, Right, what? Mr. Chairman, the proposed amendments have been circulated. There's another set of amendments to the fourth schedule. Yes, just some minor matters to the fourth schedule. You have that? No, there are some additional ones.
Clause
Right.
1, Mr. Minister, you have an amendment that we put the clause 1 to 3.
You can proceed, Mr. Speaker.
Do I put clause 1 to 3?
No, I have a question on clause
You have a,
clause 2.
okay.
Clause 2.
1.
Yeah. So you could put clause 1, sir.
I put clause 1. Those in favor?
Aye.
You have an amendment for clause 1, Mr. Trump?
No, Mr.
Those in favor? Those against? As have it. I put clause 2.
Yes, Mr. Chairman. I have two questions on clause 2. In relation to the definition of guardian, where it says in relation to a child, includes any person who has for the time being the charge of that child. Would that include parents? Is the reference to any person there intended to include the parents of the child within the definition of who a guardian is? Or is it persons other than the parents of the child who fit this description?
I suspect it includes parents.
So the definition of guardian would include parents?
Yes,
All right.
because the parent has not been defined. Huh?
I should. Yeah. Well, I would say so. So I think, so I'm just saying that if that is, if the norm is that guardians are different to parents, I think the definition ought to make that clear.
My understanding from that AG is that it would not include parents because parent has legal control.
But it says any person. It includes any person. So that language in and of itself suggests that it would include parents.
That's the point. Can we stand it down for the moment?
Yes, sir,
okay.
please. The other question I have for you is in relation to the definition of suspended sentence order. It makes reference to section 38, but what about section 34(1)(e)? Because 34(1)(e) also provides for a suspended sentence order. What is this? This is another copy. This is new, or this is the same one you handed out?
Well, in that case, you're right, member.
Yeah.
Means an order made by the court under section 34 and 38.
34(1)(e), yeah.
Well, just 34, under section 34 and 38. Under sections 34 and 38. Would that be okay?
Well, yes. I mean, the drafter can indicate how specific they want to be, because 34 is a pretty large section. It has 7 subsections spanning 3 pages, so it may be useful to be a little bit more.
You mean 34?
It's 34(2) rather, 34(2)(e), not 34(1)(e), 34(2)(e). Yeah.
34(2)(e).
Yes.
All right. Well,
Yeah.
I'll ask the drafter to indicate.
So do I put the amendment to clause 2?
I think they want to. You want to stand that down and move on?
Yes, I will. Clause 2. Yes.
Don't put it yet, so if we could
Yeah.
move on and we come back to it.
Put
Clause
the amendment
3.
to clause 2.
No, there's no
No, put
specific.
clause 3, Chairman.
Put clause 3, we come back to clause 2.
We stand on
after.
clause 2, we'll return to clause 2. Put clause 3, Chairman.
I put clause 3. Those in favor?
There's an amendment
There's
to clause.
amendment, Chairman, as
Amendment.
circulated. Amendment as circulated, Chairman. Just put it that way.
I put the amendment to clause 3. Those in favor?
As circulated. No, put the amendment first, Chairman.
He has, but he just wants you to add the word as circulated. So the
Put the amendment as circulated.
I put the amendment to clause 3 as circulated. Those in favor?
Aye.
Those against? The ayes have it.
Put the clause as amended now, Chairman.
I put clause 3
As amended.
as amended, and it has been circulated.
Yes.
So I put clause 3 as
Amended.
circulated and amended. Those in favor?
Aye.
Those against? The ayes have it.
Could you put clause 4 to 7, Chairman?
I put clause 4 to
7.
clause 7. Is there an amendment?
No.
No.
Is there an amendment?
No,
in
those in favor?
Those in favor?
Aye.
Those against? The ayes have it.
Put, yes,
Yes.
put clause 8, Chairman.
I put the amendment to clause 8
As circulated.
as circulated.
Yeah? It was circulated. Clause 8. Put as circulated, those in,
Those in favor?
aye.
Those against? The ayes have it.
Clause 8 is amended, Chairman.
I put clause 8 as amended. Those in favor?
Aye.
Those against? The ayes have it.
Could you put clause 9 to 12, Chairman?
I put clause 9 to 12 as amended. Those in favor?
Aye.
Those against? The ayes have it.
Well, sorry, in clause 9 though, sir, if I'm sorry. We'd had a discussion about the role of the consent of the victim.
No, that's 21.
But it's dealt with in 9.2c.
Yes, it did indicate, Chair, in the discussion, in the closing, that where the consent of the child is unreasonable, then the Child Diversion Committee can, or the relevant person can ask the court to approve.
Right, but where is the provision that gives effect to that idea?
Sorry?
Where is the provision that gives effect to that idea that if consent is unreasonably withheld, that the court may, on the application of the child or its guardian or whatever, provide the required consent? I mean, it's the sort of thing that could be put in clause 2 as a subsection that says where, in this act, there's a requirement for consent on the part of a victim.
Yes. Okay.
If such consent is unreasonably withheld, the court may, on the application of the child or somebody acting on behalf of the child,
Okay.
provide that consent.
Could I ask the drafter to just do a clause for us, please, where the consent of the child is unreasonably withheld? The consent of the child or the guardian.
Yeah.
No, it's unreasonably withheld.
Yeah.
Then the court can give the consent.
Yeah. However they wish to do it, but it's addressed in 9.2 there. 9.2c suggests that the ability of the committee to or the ability of the matter to be considered for referral is that the consent must be there. So we need that provision.
So what I'm asking is just a quick draft from it, Samantha, where it says, wherever in the act the consent of the child or guardian is unreasonably withheld, the court can be asked to grant the consent, okay?
The consent to the victim.
Yes.
It was unreasonably withheld.
Right. Okay. Could you put clause 13? Sorry. We have changed it.
I put clause 13
As amended, Chairman.
as amended. Those in favor?
Sorry, you don't have a copy? No, get a copy. No, get a
So
copy.
I put the amendment
Get a copy of it.
to clause 13. Those in favor?
Aye.
Those against? The ayes have it. I put clause 13 as amended. Those in favor?
You got it?
Those against? The ayes have it. Close.
14, Chairman.
I put clause 14
As amended.
I put the amendment to clause 14. Those in favor?
As
Wait, please. In clause 14, we're deleting 2 and 3 and renumbering the rest.
that's right.
Right.
So we're only deleted.
4, which would now become 2,
Yes.
talks about the Child Diversion Committee causing the program developed by the Child Diversion Office to be set out in writing. The Child Diversion Committee that we're referred to here is the parish committee, and the office is a centralized office. So why would the burden be put on the committee to have this program reduced into writing? Why wouldn't the office do that on their behalf? Why are we burdening the committee with that?
Why not?
Well, I just think the office is better equipped. I mean, the committee is largely volunteers and so on.
Yes, man, but I don't think it's unusual to ask them to put it in writing.
But the program is developed by the office, you know.
Yes.
So why aren't they putting their own program in writing rather than sending it in? I don't know how they'd communicate it to the committee, but this says that the committee has to cause it to be put in writing when it's a program of the office. The office should put its own program in writing.
Huh? But I don't think this is an unusual request, member.
It's a very unusual request.
No, why? To put it in writing?
No, because the program is developed by the office and is sent to the parish committee. How are they going to communicate the program to the parish committee other than by setting it out in writing? They're going to do it over the phone?
But that's the point. Put it in writing and send it in.
But it's the office's program.
Yes.
So they are the ones designing the program and sending it to the committee. So they should send it in writing. Don't require the committee out in the field to reduce the office's program into writing. Thank you.
You want to remove the in writing?
No, I think that the office should cause its program to be set out in writing and communicated to the committee.
I don't have a difficulty, but the change of word in.
They're here to do that. Yeah. But the point is that the office develops the program, so it must be developed and set out in writing so that the committee can act on it.
I don't have a difficulty. We can stand it down. That's 14.
Yeah.
Yes, just get that straightened out for me, please. 15 to 18, Chairman. 15 to 18, Chairman.
I don't have anything here.
Sorry. Would you tell me to have this thing rectified and sent to me? Chairman, 15 to 18.
I put the amendment to clause 14.
No,
They're
could
not ready with
you
it.
stand it down, please,
Yeah,
Chairman? We're standing
Not
down
ready?
2, 9, and
I
14
put
for the
clause
moment.
15 to clause 18.
Aye.
Those in favor?
Aye.
Those against? As of it.
19.
I put the amendment to clause 19.
Yeah.
Aye.
As circulated. Those in favor?
Aye.
Those against? As of it. I put clause 19 as amended. Those in favor?
Aye.
Those against? As of it.
Could you put 20 to 22,
I
Chairman?
put clause 20 to 22.
Yeah, just to note an editorial, just to make sure it's picked up. In clause 21, 1 in the third line, the word specified is spelled wrong.
The term what?
Specified, the word.
Oh, yes.
Yeah. The I is missing. The second I is missing.
Yes.
Yeah, just
Typographical. Yes. Could you put
I put clause 21 to 22.
no 20 to
Those in
20,
favor?
20 to 22.
20 to 22, Chairman?
put clause 20 to 22 as amended.
Aye.
Those in favor?
Aye.
Those against? Ayes have it.
23. As amended,
I
Chairman.
put the amendment to clause 23. Those in favor?
Aye.
Those against? Ayes have it. I put clause 23 as amended. Those in favor?
Aye.
Those against? Ayes have it.
24.
I put clause 24. Those in favor?
Aye.
Those against? Ayes have it. I put the amendment to clause
No.
25.
I put to 25. Put the amendment to clause 25, Chairman.
That's what he was doing. The amendment. There's an amendment to clause 25 on the sheet.
Yes.
Those in favor?
Aye.
Those against? Ayes have it.
You didn't put the amendment to 25?
Clause 25 as amended.
You have
No, we're at 25. Put clause 25 as amended, Chairman.
I want to put clause 25 as amended.
Yes. Aye.
Those in favor?
Aye.
Those against? Ayes have it.
Clause 26 as amended. Put answer.
Amendment to clause 26. Those in favor?
Aye.
Those against? Ayes have it. I put clause 26 as amended. Those in favor?
Aye.
Those against? Ayes have it. I put clause 27.
Aye.
Those in favor?
28.
Those in, you say you have
No, for 28, no. 20, the amendments to clause 28, Chairman.
those in favor?
Aye.
Do you have an amendment to clause 27?
No.
Therefore, I'm going to put clause 27. Those in favor? Look here, let's get this thing straight. We're dealing with clause 27. You have no amendment to clause 27.
No amendment,
I want to
Chairman.
put clause 27. Those in favor?
Aye.
Those against? Ayes have it. You have an amendment to clause 28.
Yes, Chairman.
As circulated?
circulated. Yes.
I put in clause amendment to clause 28. Those in favor?
Aye.
Those against? Ayes have it. I put clause 28 as amended.
Aye.
I put clause 29 to 30. Is there any amendment?
No.
Those in favor?
Aye.
Those against? Ayes have it. I put clause 31 as amendment. I put the amendment to clause 31.
Aye.
Those in favor?
Aye.
Those against? Ayes have it. I put clause 31 as amended.
Aye.
I put clause 32. Those in favor?
Aye.
Those against? Ayes have it. I put the amendment to clause 33. Those in favor of the amendment?
Aye.
Those against? Ayes have it. I put clause 33 as amended. Those in favor?
Aye.
Those against? Ayes have it. I put clause 34 to 35. Those in favor?
Aye.
Those against? Ayes have it. I put the amendment. I put amendment to clause 36. You have an amendment to clause 36, Mr. Chuck?
Yes, as circulated.
I put the amendment to clause 36. Those in favor of the amendment? Those against? Ayes have it.
Aye.
I put clause 36 as amended.
Can't hear it.
Those in favor?
Aye.
Those against? Ayes have it. I put clause 37 to
37
39.
to 39.
Those in favor?
Sorry.
Aye.
Those against? Ayes have it.
Sorry,
I put the
what-
No,
amendment
hold
to
it, Chairman.
clause 40.
Mr. Chair, I know you're on a roll, but if you could, in 36, there was just one point which is not addressed here and should be, which is in 36.2, the words to the benefit of the community in which the injury, damage, or loss was suffered.
Come here. Hello.
Those are, I think, closing words. 2 reads, in order to make amends may provide for the making of amends by non-monetary compensation, including the rendering of unpaid service, or monetary compensation. And either of those are to the benefit of the community in which the injury, damage, or loss was suffered. Because the non-monetary compensation would also be to the benefit of that of the community. So I think that those words are not just solely applicable to 2B, but apply to both A and B. The words to the benefit of the community in which the injury, damage, or loss was suffered, whether it be non-monetary or monetary compensation, it's really for the benefit of the community. It's on page 35.
I'm sorry, member.
Yeah.
What's your proposal?
I can't hear you, Mr. Johnson.
What's your proposal, Chairman? Member?
No, I'm saying that in the words to the benefit of the community in which the injury or damage or loss was suffered really are closing words. They should go back to the margin, because whether it's non-monetary compensation under A or monetary compensation under B, in either case, it is to the benefit of the community in which the injury, damage, or loss was suffered. As it's worded here, it suggests that it's only monetary compensation that is for the benefit of the community. But I think the intention is that whether it's non-monetary compensation in the form of unpaid service or some monetary compensation, in either case, it is to the benefit of the community in which the injury, damage, or loss was suffered. So it's just simply a question of putting a comma after monetary compensation and carrying the words to the benefit of the community in which the injury, damage, or loss was suffered back to the margin.
Mr. Golden, I understand that it's a printing error.
I can't hear you, Mr.
And
Sorry,
I understand it's a printing error.
It's a printing error. Well, I agree, but I think it's important because if it makes sense, grammatically it makes sense in its current form.
Yes.
So I think it's important to fix it, because it's not a question where somebody could say, oh, it's obviously an error.
Could we just make a note of that, Clerk of Parliament, so that it can be modified before it goes to the Senate?
Thank you.
So thanks, member.
Thank you,
Could we
sir.
then put the section?
Yes.
Okay, we're going to go on then. We're going to put 37 to 39.
Yes.
Thought we had put that already, but
Go ahead, Chairman.
those in favor?
Aye.
Those against? Ayes have it.
Sorry, but in 37, I'm sorry, but in 37, the idea that the court can make a diversion referral order in respect of any other offense, that would include even things like murder?
No. Only those within the child diversion schedule.
No, but it says notwithstanding the diversion offenses specified in the first schedule.
Oh, yes.
A court may make a child diversion referral order in respect of any other offense.
Well,
that seems extreme. Because you have a schedule of the types of offenses. Shouldn't it be any other offense for which the penalty not exceeding X years is applicable? I mean, to have it child diversion for things, very serious offenses.
Yes, I think we really wanted to give the court the discretionary power to deal with as many offenses as possible. But the question you're quite right to put, should it be limited?
I mean, you have a lengthy first schedule, so with many different offenses.
And they're all minor offenses, as you can see, fairly minor.
And you have the capacity to amend it. With the amendment you're making, you can amend it by order, subject to affirmative resolution. By regulations, yeah. Subject to affirmative, you can amend the schedule. So I don't know, but it just seems too open-ended to me to give the court.
Could we remove any rather than say in respect of other offense?
Well, notwithstanding as well. I mean,
You see, the any is too wide, as you quite right to say. of any other similar offences, which would sort of restrict it within the rubric of what is in the first schedule. Yes.
I mean, you do have in the first schedule an offence under any other enactment for which the penalty is imprisonment for a term not exceeding 3 years.
That's right.
So you have a catch-all there that covers
Right.
any minor offence, whether you've listed it or not.
So what I was suggesting,
Yeah.
member, is if we say in respect of any other similar offence on in the section in the first schedule.
I think if you're low.
I don't know how, you know, the categories of offences in first schedule are such a wide array of offences. I don't know how you would construe it as to what is similar or not.
But the point about it is that you have to trust the judge's judgment, so that I wouldn't expect them
So
to
maybe
be
you could
really
say
put
other,
in, you know.
other offence which to the court appears appropriate for being disposed of in that manner.
No,
Something like that.
in other words, the idea was to give the judge the discretionary power. I would not expect a judge to be given a diversion to murder. Right?
No, if you, my view is, Mark,
Yeah.
if you allow for the Euston generous rule to apply,
Yes.
which give the court a sort of framework for interpretation.
And you see, Mark, may I say, colleagues?
I just don't think there's a genus. If you look in the first schedule.
May I
it's
say,
such a-
colleagues, you see, there may well be some serious offences, but because of the nature and circumstances, they may well be appropriate for child diversion.
Yeah.
So I'm not denying that, you know, some serious offences could be involved, but because of the nature and circumstances, a child may well have been not necessarily the first offender, but might well be in the company of someone who commits the offense. And therefore, just because the child is in the company, may well be charged with, you know, with murder, but is not the actual offender. And in matters like that, it may well be appropriate to have child diversion. So I would want a member to leave it to the good judgment of the judge. You know, I would leave it to the good judgment of the judge, because there will be circumstances where, even though it is murder, the child is an accomplice and just happen to be in the company, but is charged with murder as an accomplice.
I would at least preferred, if you're going to leave it as wide as any other offence.
I think, you see,
I would have preferred if you added some language that says that to the court it seems appropriate to be disposed of through the
But that's
through the child
implied.
diversion.
But that's
it's implicit. But I think it would at least give some clear. It would give some clear guidance, even on appeal.
But that's implied, though, Mark. It's implied. It's implied.
It is implicit, but I think it would be better to state it.
No, I don't think you need to go into. I would expect that in the child diversion, a judge would know what would be appropriate, especially considering the nature and circumstances of the offence.
Yeah, but you've given them no guidance in the language
No,
whatsoever.
but
You've just said in any other offence. The court can make a child diversion order.
No, but with due respect, you're dealing with an overall system where you're trying to assist the child, and if it's a circumstances regardless of the nature of the offence.
I think you should say something that may make a child diversion referral order in respect of any other offence where the court considers that to be in the best interest of the child and the administration of justice.
Well, if you want to add that,
Yeah.
but it seems to me to be implied. It's clear.
I would prefer to add it because I know, for example, in the debate, this issue about any other offence was raised by some of the members. As I think, for example, Member Daly had a grave concern about the idea that murder could be dealt with through diversion.
What is being proposed, Chairman,
Yeah.
is that we add at subclause 2, what to my mind is obvious, but just out of an abundance of caution, as suggested, any other offence where it is in the best interest
Of the child
and the national interest.
Yeah. I mean, national interest, I just said due administration of justice.
Okay, where it is in the best interest of the child.
And the due administration of justice.
That's implied, though.
Yeah.
Where it is in the best interest of the child.
No, but that's the whole scheme.
It's not only the child's interest, though,
I think the purpose of this
It's always that.
is the best interest of the child. Not the best interest of the child is paramount. Full stop. So it
And why is the victim's consent required?
That's my view.
If there are other interests at play,
Yes,
because it's a situation where
but-
there may be a victim of the offence whose interests the legislation takes into account.
All right.
Yeah.
Where it is in the public interest. Or where it is in the interest of justice.
I like
I have no doubt that it is implied, but if you want to add
Yeah.
that, where it is in the interest of justice,
to do so, yeah.
to do
Right.
so. Okay,
Yeah.
I know it is implied, but you want to add that, we
I
add
think
that.
so.
Where it is in the best interest of justice. Where it is in the interest of justice.
Yeah.
Okay, can you put it then, Chairman?
You have an amendment to clause 37. I put the amendment. Those in favor? Mr. Chuck, do you have an amendment to 37?
No, Chairman.
Just the words in the
Just the word that was added
Yes.
as
in the interest of justice. After the word, any other offence. Yeah. No, because it's not the child's interest that this is the, because there may be a victim. And there may be a
Will
victim
somebody make up
of
the
the-
mind whether it's an amendment or it's not an
But
amendment?
it must also, it can't only be the child.
Do you have an amendment to 37?
Yes, Chairman, we add
I
them.
put the amendment.
Yes,
This
Chairman.
could be murder.
Those in favor?
Aye.
Those against? Ayes have it. I now put 37 as amended. Those in
Aye.
favor?
Aye.
Those against? Ayes have it.
38 and 39 now,
Nearly
Chairman.
done.
Huh?
Yeah. So you have the amendment on the sheet.
I put clause 38 and 39. Those in favor?
Aye.
Those against? Ayes have it. I put the amendment to clause 40. Those in favor?
Aye.
Those against? Ayes have it. I put clause 40 as amended. Those in favor?
Aye.
Those against? Ayes have it.
Could you
I put the
clause-
first and second schedule.
No. Could you put 41 to 45, Chairman? Clauses 41 to 45.
Is there a 41? Oh, yes.
Oh, sorry. I put clause 41 to 45. Those in favor?
Aye.
Those against? Ayes have it. Where you get that from?
Okay, go ahead now, Chairman.
There's a schedule, is there a separate sheet of amendments for the fourth schedule? He said there was. Absolutely. But I haven't seen it. Yes, there was amendment under the sheet. The sheet had an... Huh?
Exactly.
The one with the date on it is the correct one.
Mr. Chuck,
Yes.
am I now to put 41 to 45?
Yes, Chairman.
I put clauses 41 to 45. Those in favor?
Aye.
Those against? Ayes have it. I put the first and second schedule. Those in favor?
Aye.
Those against? Ayes have it. I put the amendment to the third schedule. Those in favor of the amendment?
Hold on.
Those against? Ayes have it. I put the third schedule as amended. I have been told to wait.
All right.
No, it's it. It's it.
No, there's some additional amendments of the fourth schedule. Have they been circulated on the fourth schedule? Some additional amendments
We
to the
are on
fourth
the
schedule.
third schedule, Mr. Chuck.
Oh, as
And
amended,
Mr. Gordon
Chairman.
has asked us to hold.
Yeah, I'm just trying to understand where that amendment is.
The third schedule.
Yeah, where in the third schedule is it?
There's no amendment to the third schedule.
Yes, there is. In the notes to Form 1, reparations order, delete
Oh,
the words, what do they call the notes to Form 1? Delete, oh, I see, at the very end there, delete date of referral to child diversion program and substitute dates, child brought before the court. Okay, that's the amendment. All right,
put it, Chairman.
yes.
Okay, we're going to put the amendment to the third schedule.
As aye.
Those in favor?
Aye.
Those against? The ayes have it. Want to put the third schedule as amended. Those in favor?
Aye.
Those against? The ayes have it.
No, the fourth schedule,
I put
Chairman, there are some additional amendments that were circulated.
Amendment to the fourth schedule.
Yes, Chairman, there are amendments. There are two sets of circulation. Is the next set circulated? Oh. So so put the fourth schedule as amended, Chairman.
I put the amendment to the fourth schedule. Those in favor?
Aye.
Those against? The ayes have it. I put the fourth schedule as amended. Those in favor?
Aye.
Those against? The ayes have it.
No, Chairman, there are three clauses that need to be looked at. Could we
Recommit 2, was it?
Could we recommit clause 2 first?
Before you recommit clause 2, Mr. Chairman, you ask if I am in favor of 41, 45. I have said I, on blind faith, I don't see anything before me that says 41.
It's in the bill.
It's in the bill. It's in the
They're
bill.
in the bill. The clause is in the bill. They're not in the sheet.
There are no amendments, Leader of the House. There are no amendments. There are no amendments to it. Yeah. Okay. Clause AG.
We are going to proceed to the fourth schedule.
That's finished.
Mr. Chuck.
You have finished the fourth schedule, Chairman. So what AG, what you say about the guardianship? I can't, just come here and let's go.
Asked to recommit clause 2. Those in favor? Those against? The ayes have it. Clause 2.
The question of the guardian, my understanding is that the definition here includes everyone who has some control, and maybe the parents, over the child, okay? Right. And it is in the Restorative Justice Act where it includes everyone. Now, in relation to 9.2, member, what is happening is that the...
So, did we make the amendment to the suspended sentence order to make reference to 34.2?
Yes.
We did.
Yes. We are going to add 34.2E.
In the definition of suspended
In the
sentence.
definition of suspended.
Because it's two different routes by which an order can be made, under 38 or 34.
Or 34.2E.
Yeah.
Okay? Now, member, in relation to the question of adding consent to section 9, my understanding is that consent was dealt with in the Restorative Justice Act, where it means that if within the Restorative Justice Act, you see, where it says what came in the Restorative Justice Act reads like this: where the trial of an offense other than an offense in Part 2 of the third schedule, similar to what we have, has commenced in respect of a person and has resulted in that person's conviction. Is that the right section?
But, Mr. Minister, in restorative justice, the consent of the parties to engaging in restorative justice is fundamental to restorative justice. You can't do it. You can't embark on restorative justice without the consent of the victim, because it's a victim-centered approach.
Yes.
But in child diversion, it may not be a restorative justice process that you're being diverted to. It could be treatment by a psychologist. It could be some kind of community service which is wholesome to the development of the child. RJ is just one possible aspect of what the diversion process may involve. So I don't see why the victim's consent should be the end of the matter.
No, member, the feeling that we're in restorative justice, it can't take place unless the victim consents. The feeling also in child diversion, unless the victim consents and is a party to how the offender is to be treated, it should not take place either. You see, what you're saying is that the consent of the victim should not be overriding.
I'm saying that the consent of the victim should not be a veto.
A veto.
To the diversion process being possible. Because as presently worded, it is like a jurisdictional point. It's as if the victim says, no, I want this person to be prosecuted in court
Yes.
for one of these first scheduled offenses. That's the end of the matter.
Right.
No,
So-
I don't think that's right. I think that if the victim may just be unreasonable in not wanting the child to benefit from the diversion process. And
Yes.
we've heard earlier about the centrality of the best interest of the child and so on. So to give the victim an overriding veto, I'm not saying that the victim's consent should not be sought. The ideal would be that the victim consents. But if that victim, let us say, is an adult and the child is somebody of a vulnerable age who needs the benefit of a diversion program, I don't think that the victim should be able to say no and just stop it dead in its tracks without any capacity for the court to rule otherwise if it's clear that the decision to deny consent was unreasonable.
Well, you see, no, I must admit in our discussion, I thought if we don't get the victim's consent, if it's unreasonable, but the feeling of what I'm being instructed is that the feeling is that in order to settle the matter, especially within a community, the victim should not be sidelined, especially if the victim is adamant that they want their day in court. You understand? So the victim may well say, this is a matter which I feel should be prosecuted, and so if the matter goes to court, that is when the court could maybe...
I think that's a conceptual error on the part of...
No, I would...
Because I think that in the context of restorative justice, it is intrinsic to the process that it must be a consent-based process.
Well,
but for child diversion, that's not necessarily so. The child may be benefiting from diversion in a variety of respects, not just through an RJ process. It could be through therapy. There's a lot of different potential routes to diversion and the benefits that diversion can give the child. And I don't see why the victim, if they're being just, they want their day in court and they're being adamant. The guy stole their mango and he must not go to diversion. He must go to court and be prosecuted for larceny. I can't buy that.
Well,
you know, that may,
right.
why should the victim...
Just to Wayne, Minister, my understanding is that the consent of the victim is not intended to be a veto on a child being referred to the program and out of the regular criminal justice system. So if it is worded in a way where if consent is not given, then the child becomes ineligible for a diversion program, it may need to be revisited.
AG, and on my reading of it, that is the effect of the wording in 9.2. And also, in a later provision, which requires 21.2. And that, to me, would undermine the efficacy of this legislation, which I wouldn't want to see happen because it is so important.
Right.
Well,
sorry, Mr. Chairman.
I think we could address it very simply, no. We could say in 9 subsection 3, where the consent, I will draft it, where the consent of the victim is unreasonably refused or refused unreasonably, the direction of the court should be
maybe so.
Simply that the withholding of consent by the victim shall not operate as a bar to the child being referred to a child diversion program.
So where the consent of the victim is withheld unreasonably, a court order should be sought.
Yeah.
Okay?
Diversion may not proceed unless the court so orders.
All right. May I just say, subject to a proper wording, we will approve it, okay?
But that language should be imported in 9, but also in 21.
That's right. But we can say where the consent of the victim in this act.
Yeah, but I don't think you can put in 9.3 and say if you're going to do that.
All right. Use that framing and it will be regularized by the draftsperson.
Right.
Okay? The other thing, member, is clause 14. Clause 14, you had raised the last matter is clause 14.
Yes, what was 4, which is being renumbered, yeah.
We had removed, so it should now read, clause 4, the child diversion program developed under subsection 1, okay? Shall be in writing, stating the child, so it should read, instead of that, what we have there, the jurat should read, the child diversion program developed under subsection 1 shall be in writing, stating, and it continues. Okay?
Well, no, sorry. Just read the entirety of 4. Before implementation of a child diversion program.
Right. We're not using that. We're going to. We will delete what is there. And write the child diversion program developed under subsection 1
shall be in writing.
Shall be in writing, comma, stating.
Oh, okay.
What we have.
So
there.
that's a new chapeau.
That's a new chapeau.
Okay.
So the new chapeau to the original 4, which is now 2, should read the child diversion program developed under subsection 1 shall be in writing, comma, stating what is there. Okay?
Yes, sir. But I thank you. I think the other point that we just finished, which is to be, I think that needs to be drafted, and we need to deal with it. We can't just leave it up in the air and say we have to decide how it's to be fixed and fix it. And I personally think the best place to fix it is in section 2, and add a subsection 5, 2.5, to see in this act, wherever the consent of the victim is required, if such consent is unreasonably withheld, the matter may only proceed to be referred to diversion if the court so orders.
With an order of the court. Yeah. Can we agree to that, Samantha? Huh? No, what the member suggested that it be a part of subclause 5, 2.5. So, Chairman, may I ask for recommittal of clause 2?
Sorry. Huh?
A recommittal of clause 2.
Mr. Chuck, will recommitted clause 2, has it been amended? What we did, we recommitted.
This is what we should put. The whole justice of the case, the judge can still make the order.
Yeah, no. No. All right. So, Chairman, can you recommit clause 2?
Mr. Chuck.
Yes.
You want me to put clause 2 now?
Yes, recommit clause 2.
Is there an amendment?
Yes.
So I put the amendment to clause 2. Those
no,
in favor?
we are going to add, we will add clause 5, subclause 5 to clause 2.
Yes. Otherwise.
Clark, did you get the wordings from you got the wording?
I don't want to say it because I don't want anybody here, but this is very untidy.
It's actually not untidy. This is untidy. This is the part of the committee.
Where in this act the consent of the victim is required and is unreasonably withheld, the matter may only proceed to a diversion program if the court so orders. And
Mark, read it again so the clerk can have it.
Oh, okay, yes.
Mr. Chuck, let us...
Where in this act?
Let us recommit clause 2 now.
It is recommitted.
I don't think it needs the word only. It doesn't need the word.
Yes, Chairman. No. So we're adding, Chairman, we're adding to clause 2 an additional clause, subclause 5.
Yes. And
which will read as follows. Go ahead, Mark.
Where in this act the consent of a victim is required, comma, and such consent is unreasonably withheld, comma, the matter may only be referred to a diversion program if the court so orders.
If the court so orders, yes.
Sorry, Minister, I'm just wondering, do we need the word only? Only?
No.
In other words, the matter may proceed, so we don't need the word only.
Thank you. Delete the word only.
Yes.
Yeah. May proceed to a diversion program if the court so orders. Yeah.
Wonderful.
I'm going to then put, Mr. Chuck, I'm going to put the amendment to clause 2. I put the amendment to clause 2. Those in favor? Aye. Those against, says of it. I'm going to put clause 2 as amended. Those in favor? Aye. Those against, says of it. I put clause 9. I hear yes, I hear no. Which one is the right one? Is there an amendment to clause 9?
We've addressed that by the amendment to clause 2. Was
So
to deal
clause
with the clause 9
remains.
issue.
So I put clause 9 then.
Aye.
Those in favor?
Aye.
Those against? As of it. I put clause 14.
We had amended that already,
There's an
Chairman.
amendment to clause 14.
Yes.
You're ready with the amendment?
We did,
I
Chairman.
don't put the amendment to clause 14. Those in favor?
Aye.
Those against? As of it. I put clause 14 as amended. Those in favor?
Aye.
Those against? As of it.
That's it, Chairman.
Where do you want us to go now, Mr. Truck?
Finish.
How much amendment now? How much amendment,
Mr. Golden, how many amendments?
Oh, them, sir. I only initiated most of them.
Okay, well, let's put the title and the enacting clause. Those in favor? Those against? As of it.
How much?
I'd like to put that, but I need to know how many amendments. Okay. The question is that I do report the bill as having passed committee stage with 33 amendments. Those in favor? Those against? As of it. Mr. Trucker, I'm going to ask the leader of government business to have a discussion with you concerning these amendments, that you carry the bill and the amendment together instead of carrying the amended bill. That's would not be accepted by. I do report the bill as having passed committee stage with 33 amendments.
Mr. Speaker, I now ask that the bills be read a third time.
Those in favor? Those against? As of it.
A bill entitled An Act to Facilitate the Implementation of Child Diversion in the Criminal Justice System and for Connected Matters read a third time and passed.
Mr. Speaker, it is not intended to do any further business today, so I ask you to adjourn this Honourable House until May 15th at 2 p.m.
The question is that the House be now adjourned until
Mr.
the
Chairman,
15th.
Mr. Speaker, if I may. I'm reminded that yesterday I indicated to you on the request of the member from Westmoreland East that he wished to make a few comments with respect to the damages suffered in his constituency. There was no provision for that, not having fulfilled the requirements of standing orders. but you had acceded to his request in part and referred it to me, and I referred to the members most responsible for reporting on matters of that nature, and indicated that today we would furnish some information with respect to the extent of the damages suffered. We are not in a position at this time to provide the kind of information that we think would be of great value to this Honourable House. So I give an undertaking that at the next sitting of the House, both the Minister of Agriculture and the Minister with responsibility for roads. Who? Who? So I'm asking you for the I'm saying this for the records, having given a commitment. I wish to make it known as to what our intentions are in respect of this matter, and that on Tuesday we will make a report to this Honourable House on the findings of those who are now in the field determining the results.
Question is that the House be now adjourned until Tuesday, the 15th of May. And members, at 2 p.m. Those in favour? Those against? As have it. This Honourable House now stands adjourned.
Jamaica, lush, beautiful